Thanks very much, Jonas. As Jonas said, my name is Louise Oliphant. I'm the editor at Compliance Tech, and I have the great pleasure of welcoming Max Schrems onto the stage 12:30. So that's going to be really interesting, I expect. I've heard a lot of people talking about his presentation and being very excited. But first, Max, can you please just tell us a bit about what you'll be speaking about at 12:30?
Basically there was the Schrems 1 and 2 litigation, it's now called. I usually call it Safe Harbor and Privacy Shield decision. And I think a lot of people have issues on how to comply with that or what it really means. There's also a lot of the bigger tech companies that spread their own view of what this could have possibly meant. And the idea is to go through that, what the judgment was about and what is still legal to do. There's a lot of things that can still be legally done and what is probably not fixable in the near-time future, to basically weed that out and probably for people to see which category or which little bucket they fall into.
Yeah. Okay. Could you give us an example of like something that is probably maybe legal that you can do?
Yeah, so for example, American surveillance laws only apply to so-called electronic communication service providers. Sounds a bit complicated, but basically cloud providers. And there is a lot of companies that do not send data to a cloud provider in the US. So if you're a hotel company and you send it to your hotel affiliates in the US, they may themselves actually not fall under any of these surveillance laws, so the problem doesn't exist. And there are other situations where that may be, however, outsourced to a cloud provider, all of that, then you fall under it again. So there are these different situations. There are situations where there is what I call necessary transfers. So for example, if you book a rental car in the US because you at some point are able to fly there again, then you actually need to send that information there. There's no way around. And that is, for example, usually legal under one of the exemptions. So I think it's oftentimes useful to be a bit more nuanced than just saying everything in the US is terrible or good, and we hope to weed these situations out a bit.
Excellent, thank you. There's also this other thing. I'm not sure you'll be speaking so much about this topic on stage, but I know that your organization, Max, NOIB, None of Your Business, has a focus on cookies this year. Could you just tell us like a tiny bit about your mission with that?
We headlined it with basically the title, Everybody Hates Cookie Banners, and I think that's a universal truth. And basically it's about how they are designed. So I think under the GDPR, they should be designed to have a yes or no option. And there's actually guidelines by the Danish DPA on that as well, on the Data Protection Authority. And a lot of companies, however, came up with having the no button like on the fifth layer in the corner somewhere where you can find it. And we started a big project, a bit like legal tech, as you now call it, to scan websites for these violations and automatically generate complaints on them. We gave companies a month to fix it. So if we said, if you fix it within a month, we're just gonna rip that complaint apart and throw it away and pretend everything was legal from the get-go, which a lot of companies did. That was actually really useful. About 2/3 of the companies just started compliance themselves. And for the rest, we now have cases. That's more than 400 cases right now in Europe. And it's basically about giving people a fair yes or no option for their privacy. Because consent is an option, you can always waive your rights. You can waive your right to life and just jump off a bridge. So you can also waive your right to privacy, but you should really have the option to jump off or not jump off and not just be thrown off. And that is basically what this is about. It's now oftentimes called dark patterns or deceptive designs or that whole thing to make it really hard for people to say no, which I think is not the idea of a self-determined way of processing your data or not. People should actually have the yes or no option.
Yeah. Well, that makes sense. I actually recently read, I think, on the EDPB's website that they have set down a task force on this. Can you comment on that? Like, what does that mean?
So the EDPB now, for a couple of these international cases that are large, and we've also brought 101 complaints on data transfers to the US, it kind of makes sense that they get together and kind of group things and try to work together on these issues, because otherwise we'll have 27 different decisions, or if you add Germany, 17 on top, because they have a local DPA for each state in Germany. And that is basically these task force. So we actually only saw that on the website as well. The EDPB, I think rightfully, is usually a bit closed up. They do their thing and then tell you what came out of it. And they usually don't want kind of lobbyism or people intervening too much. which I think is fair. It's a bit like with courts. So we don't know too much what their plan is. We'll basically just provide them with the documents and with the submission so that they have everything in order, and then they got to make their own decisions, I guess.
Okay. Excellent. Thank you very much, Max. I think that's a little teaser you'll get here before Max goes on stage, as we said before, at 12:30. But yeah, thanks very much for listening to this short interview with Max Schrems.